And this time we have selected a very interesting topic of compulsory delisting. But in the compulsory delisting topic, we have put in one possibility of relisting of delisted company and how it can take place. We have some example which we have done. So we want to share with you. Second is the compulsory delisting part is very scary. So sometime we have a listed company, we think I have not complied, stock exchange had delisted, so my work is over. So this is a wrong approach of everyone who thinks in this manner. Now, as you are aware, compulsory delisting under SEBI regulation not only removes company's security from the exchange, but also trigger 10 years debarment from assessing the capital market for the company. Its promoter company is promoted by such promoter, whole-time director, and person responsible for compliance with security law. That is very interesting. This is the compliance officer or the professional. And second is additionally the promoter group, whole-time director, and person responsible for the compliances are ineligible become director of any listed company until the exit option is provided to the public shareholder. So it means that your company is delisted, but then you are not eligible. All these people are not eligible, and their eligibility will start when the delisted company is giving exit offer to the public shareholder. It is very scary, and it is a situation where people should understand that it is not just a small punishment, it's a big punishment. So today's webinar will help promoter, director, compliance officer, legal professional, stakeholders understand the implication of this delisting and how this compulsory delisting will affect, and explore the pathways, possible pathway after debarment, discussion, practical step to navigate regulatory landscape, and possible pathway for relisting of the company. That is another option solution. Today, we will discuss various points relating to delisting. So I'm dividing the entire webinar into two parts. One is the delisting and second is the possible relisting. So first part of delisting will cover overview of regulatory regulation relating to compulsory delisting, consequence of compulsory delisting, legal remedies and compliance strategy post delisting, and learning from real case study what worked and what did not, and what is the solution. Then practical roadmap, how companies can get ready for the post compulsory delisting phase. And the last, we will discuss this separately, the possibility of relisting of companies which is already delisted, and various case studies with us, some case where our team has done, that we will discuss. And for today's webinar, we have invited the galaxy of the speaker, and I welcome our first speaker, Mr. P.K. Vidalesh. Mr. Vidalesh is a former CGM, SEBI. He is a rank holder chartered accountant. He possesses over 42 years of broad board quality experience in corporate finance, regulatory, investigation, adjudication function. During his tenure in SEBI, he had headed several departments and was involved in framing regulatory policy and investigating, educating market misconduct in securities market. He has made a number of presentations, delivered talks at various national and international fora, and led training program of emerging international security regulators, like various other regulator of the other part of the world. He has been a member of various committees constituted by SEBI, RBI, Ministry of Finance, MCA, International Financial Service Authority, ICSI, ICI, and ISCO. He is presently providing advice on security law and financial strategy. He is also sitting as an independent director on board of reputed listed companies. Mr. Vidalesh, we welcome you, and I can just tell you that I interacted with so many people in SEBI, but the way he has the command on economy and the security market, and because of the chartered accountant by nature, he is master of numbers. Uh, his understanding of the market, understanding of the subject, and understanding of this not on the over, it is deep rooted. He understands the market, he understands the implication, he understands how to do this and how to solve this. So I welcome Mr. Bindalesh for this program. He has done a lot of work in delisting of SEBI. Uh, when the law was framed, he was involved and he has done various things. So today we will understand what is the jurisprudence of delisting, how they see, why this tough law is there. All these points will come when he will give a presentation. I welcome you. Then we have Anjali Agarwal, partner and head capital market service of corporate profession, who handles, I think, more than 50 delisting cases, small and big, and through various routes. So she has sufficient experience, sufficient issues, sufficient pointer in her kitty today to discuss and to get aspects. Then we have a Ravi Prakash, associate partner, security law and corporate litigation, corporate professional. Ravi has a brilliant mind of young advocate, and advocate one who knows security law jurisprudence, that is very, very important. He has that knowledge. And the most important thing, in few recent cases, he has won and he has done the relisting of the delisted company on various grounds. So we will understand from Ravi's side, we will see how this delisting can take place in the relisting process. Friend, so this is our today's structure. What we will do first, Anjali will give the presentation of all about the compulsory delisting and relisting. Then I will request Mr. Bindalesh to tell about the jurisprudence of the delisting, regulatory aspects, why it has come, and then Ravi Prakash will cover the case law and specifically the relisting part. Now, friends, and then we will have a question answer on this. So the basic point is the issue is coming that why the delisting process is becoming so complicated, so tough. So the point simple is exit fairness. That is one part. Shareholder must be given opportunity, because today you are a shareholder and now company is deciding for delisting. So you will get fair listing amount, fair amount of the company's value. Now, if there is a compulsory delisting, then the question is, you have done violation and the result is that I am facing problem, I am losing my money as an investor. Then regulatory trust, that is another point. Promoter must not misuse delisting process. So one, they will go for delisting of the company and then again they are starting another company. So you are not able to manage an existing company or you are starting something new. Then regulatory trust is essential, because otherwise investor will lose faith. Transparency, the reverse book building and the valuation must be open and justified. That is a SEBI's point. Then reputational accountability, like debarment and director disqualification, ensure deterrence. So sometimes people think, okay, if we are not complying, no problem. But they should realize that this is very tough. You can't become, you have to out from the corporate world and you have to do something with so many handicaps. Due process, even compulsory delisting must follow natural justice. That is another aspect. Now, when we see this, that what is the position in India? So I told you investor protection is supreme. Natural justice is also required. And Bombay Stock Exchange has told in electro steel case also that proper hearing and other thing. And in the relisting case also, the natural justice issue is coming, because that is the one challenge which stock exchanges are facing. Now, re-entry of the capital market is not possible. You have to come with a, uh, if you want to do this, then you have to give exit, you have to comply, and then you have to bring out IPO through the normal process. Then your relisting is possible. But there are some exceptional cases which Ravi and Anjali will discuss. Now the question is, what is a global jurisprudence, global market is behaving and doing in the uh, delisting? So in the United States, no equivalent to SEBI 10 years debarment is not there. Voluntary delisting allowed subject to shareholders approval, public notice, fulfillment of action as SEC disclosure norms. Compulsory delisting happening on non-compliance with listing standard, like minimum capital, minimum market capitalization price, but they don't have a 10 years debarment. That tough law is not there. In USA, LSC, they regulated under UK Listing and Companies Act 2006. Voluntary delisting requires 75% shareholders approval, 20 business days advance notice to market, and relisting requires reapplication and full regulatory compliances, like in India, that we are also saying. Singapore is a main board rule to 1307, allows voluntary delisting subject to exit offer to shareholder, independent financial advisors fairness opinion, and compulsory delisting occurs due to prolonged trading suspended or the other branches. Now this is one, but simultaneously there is another issue, that what are the reforms should be there in Indian delisting regulation. So one is coming in the mind that SEBI should introduce tiered regulatory treatment based on company type. Same rule should not apply to blue chip company and inactive shell company. By what is happening, by making this, sometime blue chip company or the company which are doing very good, but they are going for delisting, they come under the jumble up and they lose this, and the regulatory arbitrage takes place in this part. Now, next is when we talk about the companies, so blue chip company, listed SME, dormant company, insolvency, exit, active, traded, middle, last size. So all these things have some different parameters. The 10 years debarment rule is a little bit harsh. It should be work out something, because sometimes what is happening, the people, uh, those who are getting this 10-year debarment will not harming them, and they think that I don't want to do listing and I'm out. But sometimes it is good also, because they have covered promoter group. In the promoter group, the father is there, the son is automatically coming, and then because of son, this is happening a serious issue. Next is allow conditional relisting pathway, because relisting is sometimes the company's fault is not there and it is happening. So something we will work out, because when the law is there and you want to do something new, you have to just try to identify that what is the way out for relisting. The relisting rule should be give some pathway, maybe tough, but it should be. Minority shareholder activism is delisting is also required, because so many shareholders, when their share is delisted, they are not aware, because company play a different game, and they are not able to understand and do it. Then create a fast track exit window for dormant company. So dormant company, if they are delisted, then you are understanding that they can't give the same type of exit offer because they don't have money. So something, some formula, some things should be identified, but it should not be those company which has intentionally transferred the fund. Then strengthening post-delisting disclosure and compliance, because what is happening, that after the delisting, there are so many shareholders are still there, and Anjali will tell you what is their role. That is sometimes it is not very clear, and that should be very clearly mentioned. And the technology, Now, what is happening? There's so many shareholders are making complaint, and in this complaint, people are not able to get it. And I can tell you my example. There was a company which was a delisted. I was not able to surrender. Now the company which is a delisted from the stock exchange, they have come out the buyback offer of a unlisted company. And you will not believe, we are expert in this area, and my entire team has involved in this to get that buyback offer of the delisted companies. I want to apply. I have a 200 shares of that company. It was so much Herculean task, the physical paper, doing this, and then making it. Then ultimately I have to surrender this on the last day, that no need to apply. So SEBI should also see that when the company is delisted and the shareholders which are remaining, how the company is treating them and how their system can be a effective one. With this, friends, we want to discuss the entire issue, and I will request Anjali to show her presentation on delisting and relisting, and then I will request Mr. Vidalesh after Anjali to discuss, and then Ravi. Over to you, Anjali.
Thank you. Thank you so much, sir, for setting the preface for this compulsory delisting webinar. Let me just start the presentation. So, just a minute. There is a very interesting thing that happened over the years that we noticed that by virtue of compulsory delisting, the value of thousands and thousands of shareholders is getting eroded. I'll tell you during the presentation that how many companies have been delisted over the years, and presuming that even a company has only 1,000 shareholders, a very, very conservative view, still my presentation is visible.
No, Anjali, no.
Not. No, it's not. Just a minute. Shivam, 1 second, please. Hmm.
In the meantime, you tell about this background.
Yeah. So, over the last 3-4 years, almost 500 companies have been delisted. And considering that these companies have only a very minuscule of 1,000 shareholders, that means that the number of shareholders who have lost the value runs into lakhs of people. So, how do the people get the value back? That is where this entire thing came into picture, that is compulsory delisting in any way desirable? Why it happens that a company which comes out with an IPO with great fascinations or with great hopes in mind, why does it reach the stage of a compulsory delisting ever?
शिवम, आप अपने में दिखा दो.
Yes, sir, just a minute. I think there is some technical glitch. Yeah. Is it visible now?
Yes, visible.
Yeah. So that is where the concept of this compulsory delisting came in. While preparing the presentation, while doing the research, we felt that the moment the words alphabets DE get added to any word, that means it's a negative thing. And coupled with it, if the word compulsory is also attached to it, that is like sone pe suhaga, kharab, or situation kharab hi ho rahi hai. So but that doesn't mean that it is the end of the world. There are possibilities of relisting, there are possibilities of saving the company from reaching this kind of a situation. Under the delisting regulations, I think we all know there are two kinds of delisting. One is voluntary. As the name says, voluntary is as as at the will of the company or the promoters of the company. The procedure is defined therein, and we'll not be going into the procedure with regard to the voluntary delisting. But the major difference between a voluntary delisting or a compulsory delisting is that in case of voluntary, relisting is possible after a period of 3 years. But in case of compulsory delisting, I'll be taking up in details in the next slides. So what is compulsory delisting? Delisting is removal of a company's name from the stock exchange by an order of the exchange. As the name says, compulsory delisting. So that is a compulsory action which has been taken by the exchanges against the company. It is generally triggered by non-compliances or fraud or disappearance, and it is a regulatory enforcement action against the company. When we talk about delisting, at times it appears that delisting is intentional. The companies or the promoters, they can come out, they can decide upon ki, okay, let's go in for compulsory delisting. But no, generally that is not the case. Only 1 year of non-compliance erases the decades of credibility and trust. We have seen many, many big names. Pawan sir took the name of Electro Steel. We have seen Cox and Kings. Once upon a time, there used to be big names. We have grown up seeing those names become a big company. But then what happens all of a sudden that it goes into the shambles and reaches the level of compulsory delisting. I compare compulsory delisting to the coma, your listing status being in coma. Nobody wants to remain come into that stage. There are various stages, there are various steps which are there, and one can very well prevent this kind of a step being undertaken well in time. Now, what are the grounds for a compulsory delisting? As per the law, it's very clearly mentioned that if a company has been suspended for a period of more than 6 months, exchanges can go in for compulsory delisting. Then, if a company is a vanishing company or there are the promoters go untraceable, the exchanges can compulsorily delist that company. If a company fails to maintain the MPS norm, minimum public shareholding norms, or there are fraudulent or illegal activities going on in the company, and the most common reason remains non-compliances with the listing regulations. The first one, suspension for over 6 months, and non-compliances with listing obligations are in a way interconnected. The moment a company does non-compliances with listing regulations, the next step, the dominoes effect would be suspension of trading. As I said, during last 5 years, 20 to 25, almost 430 companies have been compulsorily delisted by the exchanges. That means almost 80 companies a year. That's a huge number. So one has to look into the reasons for these. One has to look into a possible solution to avoid this. Now, what is the legal framework that defines a compulsory delisting? Delisting regulations are the basic regulations wherein the compulsory delisting is covered. There are SEBI Master Circulars, there SEBI Act 1992 is there, and Securities Contract Regulation Act, SCRA. So when I said initially that cost of non-compliance, simply delisting is not the cost of non-compliance. There are lot many things attached to it. It has a dominoes effect. Any non-compliance has a dominoes effect. First of all, the exchanges will impose a fine. There are SOP fines which have been levied by the exchange. The next step is freezing of the promoter shareholding. Exchange imposes a fine, still the company is neither paying the fine nor is it applying for waiver of the fine, nor is it complying. The next step exchange does is freezing of the promoter shareholding. Then suspension follows, and if pursuant to even the suspension and the show cause notices the company does not respond, exchange has no other option but to go in for compulsory delist. Now, the basic premise, as I said, generally 90% the reason of compulsory delisting is non-compliance and suspension. So where from and at what stage the suspension of trading comes into picture? Due date of compliance is there. Say if we talk about the results, submission of results for the current quarter and the current year is 29th of May. If a company does not do it within by the due date, exchange will issue a show cause levying the fine and also issuing. One second. Yeah, exchange will issue a notice. Exchange will mention that you have to either comply or pay the fine. If the company does not respond within a period of 15 days, it doesn't pay the fine, it doesn't comply, or it doesn't apply for waiver, exchange will go in for suspension of trading as of the company. Now, when we talk about suspended companies, there are 532 companies which are suspended at BSE and 119 companies which are suspended at NSE. These again are a loss of value to the public shareholders. Public is not able to trade. They have invested their hard-earned money into the companies, but then they are not able to trade. Suspension comes along. It's not सस्पेंशन हो गया काम आसान हो गया सस्पेंशन के बहुत सारे रिपरकशंस हैं especially on the promoter and promoter group of the company. As a result of the suspension, the promoter and promoter group demat accounts get frozen. This means that whatever shares they have in their demat accounts, they will not be able to trade on them. In many of the cases, there is a debit as well as credit freeze which happens. So if I'm holding Reliance shares and Reliance tomorrow comes out with a bonus issue, even the bonus issue will not get credited to my demat account. Those kinds of freezing actions happen. Then promoters cannot transfer their shares either by way of a sale or a pledge. There cannot be any fundraise in the company either from the promoters or from the public. Negative image, any such action brings along negative image, and the credibility gets affected, and bank funding options also get impacted. Now on the listed company, those were the impacts on the promoter and promoter group. Now on the listed company, penalties, till the time you're not suspended, the penalties continue. And most of the penalties being imposed are on a daily basis. 5,000 rupee per day, 2,000 rupee per day, depending upon the type of non-compliance. So those penalties keep on happening, keep on accumulating. Then the trading gets transferred to Z category. That's the worst of the categories, wherein you are being traded only on Mondays every week, as a result of which obviously liquidity gets impacted. Then no trading. Credibility for the listed entity, credibility is again affected. Companies cannot raise funds from the public or the promoters, and brings along the negative image for the company. Now, एक बार सस्पेंड हो गए तो क्या मैं पक्का कंपल्सरी डीलिस्टिंग में ही जाकर के रुकूंगी? आंसर इज नो. We have the option, companies have the option to stop the loss at this point in time. The company can continue as a listed entity by getting revoked. The company can, if the company still decides, no, I don't want to remain a listed entity, so go in for revocation and then proceed with voluntary delisting as per the procedures given in the delisting regulations, instead of waiting for the compulsory delisting to happen. For revocation of suspension, the company has to rectify the non-compliances, company has to pay the outstanding fines or either obtain waivers from the exchange for the fine which are due, then apply to the exchange for revocation. The company has to do, before revocation, the company has to complete all the pending non-compliances for last 4 quarters. And if the exchange is satisfied, it will issue the orders for resumption of trading. Still, if you will not do anything, if you will not take any corrective steps, your health is deteriorating, you know that, but still you're not taking any corrective actions, the last stage would be compulsory delisting. Now, the question that arises is Does this happen? Is this compulsory delisting happening in one day? No. You must have, as I said in the preceding slides also, the compulsory delisting is a detailed process. Regulations say that exchange can delist you after a period of 6 months of suspension, but exchanges give at least 2 to 3 show cause notices to the companies before they reach this level of compulsory delisting. And the companies, still, if they do not respond, then this process comes. It generally, what I have seen, exchanges take almost 2 years to reach this final stage of compulsory delisting from the date the company starts to do the non-compliances. So the entire process can be identification. Company exchanges identify the companies which are non-compliant. They issue a show cause notice to the company and to the promoters. They even provide a chance for personal hearings, which can be online or offline. Then, if no answers are given, if nobody appears for the personal hearings, then the exchange issues the compulsory delisting orders. And then the promoters have been mandated under the delisting regulations to give an exit to the public shareholders of the company. So the entire process can be summed up in these steps. Non-compliance of the listing regulations has a dominoes and a spiral effect. It will lead to imposition of fines. It will, if the company does not pay the fines, then it will lead to freezing of the promoter demat accounts, ultimately suspension. If the company remains suspended for more than six months, the company will be referred to the enforcement committee of the exchanges, and the final compulsory delisting notice would be issued. This committee, before taking up any action, again gives at least one initial public notice in the newspapers. Then it issues a final delisting notice in the newspapers. In the initial public notice, companies are given a time frame of 15 days to respond back and to make a representation. If the companies respond back, the compulsory delisting action will not happen. Now, what are the consequences of compulsory delisting? Share, as I said, shares will no longer be tradable on the exchanges. The trading will stop. The biggest restriction is 10-year restriction from accessing capital markets by the company, the promoters, the promoter group, the whole-time directors, companies promoted by any of them, and the people who are responsible for doing the compliances. That even includes the CFO and the company secretary of the company. Now, this is a very big restriction that you are debarred from accessing capital markets for a period of 10 years. So not just you, any of the company which has been promoted by, like sir gave an example, any company promoted by your son, if he wants to tomorrow come out with an IPO, he will not be allowed, he'll be restricted for a period of 10 years from accessing capital markets. Relisting is not possible for a period of 10 years, and promoters have to give an exit to the public shareholders at the fair value as is determined by the exchanges at the time of compulsory delisting. Impact of delisting is humongous for the promoter group, directors, and the persons responsible for doing the compliances. So we have tried to segregate these by using different colors. Promoter and promoter group is one category. The directors or the whole-time directors are the other category. And the people who are responsible for doing the compliances, that is the professionals involved in that company, are the other category. So impact on the promoters or directors. Company, the promoters, the promoter groups, companies promoted by those promoters or promoter group, whole-time directors or persons responsible for ensuring the compliances are debarred for a period of 10 years from accessing capital markets. This is a huge this has a huge impact because any of the companies which got delisted, say 7, 8, 9 years back, and now the next generations are stepping into the company. the business, and if those next generations are getting impacted and they are not able to come out with the IPOs, this is a huge step. It's better not to let that stage come and to stop the compulsory delisting. Now, on the promoters or directors, the impact of a compulsory delisting. Promoter group, whole-time directors, and people responsible for ensuring the compliances are ineligible to become directors in any listed company till the time they provide exit option to the shareholders. So, meaning thereby, if I am the promoter of a company which has been compulsorily delisted, I cannot even become a director in any other listed entity till the time this compulsorily delisted company gives a exit opportunity to its public shareholders. And exit is, as per the delisting regulations, it is needed to be given within a period of 3 months from the date of the compulsory delisting. Now, what would be the way forward to give an exit to the shareholders? Delisting regulations very clearly say that the promoters have to give an exit opportunity to the public shareholders. Fair value is determined by the exchanges at the time of issuance of the public notice. Herein, promoters do not have to go in for a valuation. The valuation is being done by the company by the exchanges themselves. A public announcement uh, is needed to be given by the promoters. Then whatever is the public holding in terms of number of shares, that is needed to be multiplied by the fair price that has been determined by the exchange, is needed to be kept in an escrow account. And the exit opportunity, as I said, is needed to be given within a period of 3 months. And whosoever shareholder tenders the shares, payment is needed to be made to them. In case this exit opportunity is not provided by the promoters, there can be further enforcement actions by SEBI which can be taken. Now, what are the legal remedies and compliance strategies? First and foremost is to promptly respond to the show cause notice, whether it's for compulsory delisting or the initial show cause notice, which talked about the non-compliances of the company. If you will not respond to the first one, this stage has to come. So you have to respond promptly to the show cause notice, which is issued by the exchanges. Appeal via SAT is also a possibility, which Ravi will be taking in the coming slides. Then, for the non-compliances which are there, one of the options is to apply for a waiver. If the company feels that no, the non-compliances are such wherein waiver may not be granted, so SEBI settlement mechanism can be opted for. And the last is relisting after a period of 10 years. So these were the provisions with regard to the delisting regulations and the compulsory delisting and suspension and the exit opportunity. In the coming slides, we plan to take up the cases wherein SAT has given favorable orders to the companies and go in for, so that they can go in for relisting. Sir, over to Ravi now.
Ravi, can you just explain about this?
Sure, sir. So, in IFL case, there was willingness to revive the company, and the promoters were ready to undertake that in a time-bound way they will deposit the fines or the overdues, and then they will also submit a definite plan in form of an application. So essentially, SAT was pleased to remand back the matter to exchanges to reconsider. In fact, I'll take you to one of the orders, which was in the case of Integra Limited versus National Stock Exchange of India Limited and others. This is a decision of 2018. And why I have started with it? Because in this order, SAT laid down that because delisting is akin to death of a listed company, or in a way a consequence of highest order for a listed company, because you are completely weaned out of the listed space and ecosystem. And it does not only pose consequences adverse for the promoters and directors, but also for the company itself and the multitude of stakeholders that a company has. So it's a multi-pronged consequence throwing action. Therefore, they said that you cannot deal with it in a technical way. Even if the suspension has carried beyond the period of 6 months, that in itself might not be the fit ground to delist a company and say that we can't do anything about it. That the letter of law has dried there and there is no further way. What instead SAT looks at is that whether the promoters have the will and the proper conduct which can showcase their bona fide that they are really making efforts to revive the company and that the company has got chances of revival. Please don't take my suggestion as a yardstick that the SAT or any judicial forum applies to second guess the commercial wisdom, but they certainly apply the test of reasonable prudence in assessing a plan and identifying only paper plans from the plans which are really backed up by intention and action. So that was the case of Integra. Then you've got a case of Divine Multimedia. This is a case decided in 2019 after Integra. Here also there were a lot of delay, and in this matter, the opportunity of being heard. In my reading of whatever limited it is, in my reading of law, delisting regulations is one of those peculiar laws, and there are very few laws which emphasize so much by the express words upon grant of a reasonable opportunity of being heard. While you see in the judicial precedents so many words being written for giving the opportunity of being heard, the delisting law actually in its statutory language does not leave about any doubt, and perhaps because the legislature and regulation makers were cognizant of the fact that what kind of a consequence delisting is. Therefore, they have employed a language which very clearly requires exchanges to ensure with all efforts that the company, their representatives really have a chance to be heard effectively, their representations are considered, the issues that they raise are addressed or at least dealt with, and a reasoned decision is handed out. For this purpose, you would also note that the delisting regulation does not talk about any person out of the exchange can send notice, then some other person can decide about it. There is a whole set of procedure to ensure fairness. There is a panel oblique committee that is required to be constituted by exchanges, and the composition of committee is also a statutory prescription that the committee must follow or the exchange must follow. We have seen in past cases where the committee composition was not proper, and that was the ground enough for quashing the delisting order. In fact, in one of the cases, this was the case of soft track, in which not soft track. I'll just name the case in which some assistant manager communicated the order of delisting. There was no date fixed with effect from which the delisting will take effect. There was no order of a committee on record. No composition was made was made available of the committee, and therefore SAT found it fit to quash the order and remand back the matter for reconsideration. Ma'am, you were saying something?
No, you carry on, carry on.
Yes. So you see that the possibility of relisting, essentially, I mean, there are many more cases of the same nature that, and the list goes on because delisting is not a new concept, and as the numbers tell, it is not also something which is rarely resorted to by exchanges. Sometimes there is a wave of delisting in which uh, cleaning of the listed ecosystem is done by removing the companies that are non-operational, non-compliant, only adding bad name to the listed space in the perception of the exchanges. But what happens, any wave-like action just like the wave in reality, what it does, it carries along with itself everything, something that is valuable and something that is trash. So far as the waiver action are concerned, they sometimes also take into their remit genuine cases where those actions are not really warranted, not really required, they are premature, or if mind was really applied into the facts of each case and circumstances, the outcome would have been different. So cases where the promoters may show, the directors may show that even though there was some sort of sickness, financial sickness, or operational inefficiency, or due to third party factors like a fierce competition, or external factors, they could not do well, they lagged behind for some time, but now they have the plan to revive the company, they have the intent, and their conduct also reflects the same. Then I think that makes a fit case, and Integra lays down the right law, because delisting is not a matter which you can, really see within the technicalities of the four corners of the law. What really need to be seen is, before giving the death penalty, before administering the death penalty, is there a fair case? Is there a sufficient cause that is shown by the party, that is shown by the company, to get a fresh lease of life? And I think that approach I see in SAT across the time, across the period. And before speaking in this webinar, we looked for orders more than a decade old. And I have seen this consistent chain of orders where the SAT was concerned with three things. One is the efforts and the bona fide of efforts. Second is the reason for what was the reason the company became non-compliant at the first hand. Then as I said, the bona fide efforts that they are making, and the third is the conduct, which means that nobody should approach SAT in these cases with unclean hands by garbling the facts. Go clean, even if the suspension is beyond 6 months, which is a recognized ground for delisting. There are case laws, and you see, these are not really technical matters, is recognized by the appellate tribunal. So they give due credence and due share to consider even those matters while deciding these tricky issues. The recent one is a case of Manpasand beverages. I think that's the leading case based on which many such cases have gotten relief, in which 6 months' time was granted to a company to comply. But then many parallel actions were being taken by exchanges. Therefore, appeal was filed before SAT. What was the argument? That when a timeline to take compliances has been given to us and the timeline runs for 6 months, exchange ought not to interfere or disable us from achieving those compliances by taking parallel actions. This found favor with SAT, and they granted the time and opportunities, more than once also, because sufficient cause was shown. And hopefully the timeline is still running, and the company hopefully would come out of the trap of delisting. Another case that I remember, and these are the issues that many companies must be facing. One of the issue, apart from the procedural framework, is service of the order or the notices, that directly impacts the opportunity to have effective representation before the exchanges. Many a times what happens is that companies, even though they have perpetual succession, and they die only by the law, which is winding up, or in the listed space by way of delisting. They have in their lifetime, and in many cases, may have multiple addresses. And the concept of where a company is situated is not a straight concept. Even though someone may say, from the limited perspective of Companies Act and for the purposes of few sections, few provisions, one may say that the registered office is very clearly where the company exists. But that's not very clear so far as delisting regulations or other regulations are concerned. In delisting regulation, it is very important, and as a matter of practice, exchanges also follow it, that they have designated IDs, their email IDs, where all communications are to be made. In fact, I can tell you that in a case that we handled, exchange was saying that this is the designated ID. If either you reply to this or if you reply to anywhere else, we would not consider the reply. What happened, unfortunately, is the company also in reciprocation designated two IDs. When the matter was being progressed, all the communication was done by the exchanges with those two designated IDs. But when the final order was passed, neither of these two designated IDs from the company side was considered. And the notices, the order was sent. In the order, what was the order passed by the exchange? The order was that we are giving you 6 months time to comply or get delisted, comply or get out. So that was the kind of order, but the order was never served. No proper opportunity was given. Interestingly, 2 days before the timeline was about to get over, these two designated IDs got a follow-up email from the exchange that we had sent an order so and so, you have not yet complied, you know that you'll get delisted and all. That's when the remedies were taken, and as the company had it in its luck, they were saved from the wrath of delisting by SAT, and that case is also on the path of resolution, and hopefully it will be resolved too. So all in all, one must know the set of rights that they have. It is true that one may not be able to, but in past one may have not paid fees timely. Someone's business may suffer due to adversities, internal and external. Tough times are there. Sometimes some commercial calls go wrong. But the courts do not really look at it, as I'm emphasizing again and again, very technically, that, oh, you have been suspended for more than 6 months, or that you have not paid the penalties, or that there are non-compliances. What they really look at is what concreteness of plan to resolve the situation, what ownership of what has went wrong is taken by the promoters, directors, and the concrete plan, as I said, they are willing to submit and act on in a time-bound way. Then what courts see is that there is no greater value in letting a functioning or an economic unit which has the potential of function go down the drain, because that's the loss to the public wealth. And therefore, they exercise discretion and allow a fair chance to the companies to try and remain listed. I'll tell you one more interesting point that arose in context of another SAT appeal. The name of the matter is Synergy Cosmetics Limited versus BSC. The order was passed on Feb 25th, 2019. There are two provisions in SCRA. 23L, that is the general provision which provides for filing an appeal against any order. And then there is a section 21A. This section 21A provides for a limited period of appeal against any delisting order. And 21A is very specific about delisting matter. You can only file an appeal under section 21A if you are faced with a delisting order. The view that the appeals have to be filed within section 21A was holding the ground for long. But in 2019, a strange phenomena occurred. Somebody filed an appeal under section 23L, and I'll tell you the catch. Why? Section 21A provides for a limited time, 15 days, in which appeal against a delisting order has to be filed. And if not filed, within 15 days from the date of receipt of the order, delisting order, only condonation can be done for 30 days, which means 15 plus 30. If you do not file within 15, SAT can only condone for next 30 days and not beyond it. That's what the provision says. It does not say not beyond it, but it only gives 30 days time. And we have seen in IBC, there is a similar provision which provides for 45 days and beyond which NCLAT cannot condone the delay. V. Nagarajan's case and the recent judgment in Tata's case, where not even 1 day delay was condoned. So that law is very clearly settled by Supreme Court. So 21A provides for such a strict timeline, whereas 23L provides for 45 days to file an appeal. That's the general provision under Securities Contract Regulation Act. And there is no limit or fetter on the powers of the SAT to condone the delay under 23L. The only fetter is the judicially recognized fetter, which is if no sufficient cause is shown, delay is not to be condoned, even though the jurisprudence on condonation of delay is to also balance the convenience between justice and technicalities. But that's a matter for another day. Today, the point was that a legal issue arose as to whether one can file an appeal under 23L, because if the answer was negative, then one cannot challenge order beyond delisting order beyond 45th day of its passing. But the answer was said in positive. Yes, it was upheld that under section 23L an appeal can be filed, which now essentially opens a very good opportunity for companies which are really willing to comply, but the orders have been passed in past and they have yet not challenged, or they are willing to challenge but they are in a fix how to do it because they have read only 21A. There is an order of 2019, Synergy Cosmetics Limited versus BSE, SAT appeal number 469 of 2018, which says that the doctrine of election applies, and if a statute provides for more than one remedy for one case, one is a specific, another is general, the specific will not override the general, although the ordinary interpretation is specific overrides general, but that's only in case of conflict. Not in case when you have got two remedies available, even the general is available. What jurisprudence comes into play is that it is left to the choice of the person for whom the remedy is meant for. So one can choose out of the specific and general which remedy they want. And this is called doctrine of election. So the SAT said that doctrine of election is available, and filing of appeal under section 23L was well within the power of the appellant. And then ultimately the matter was resolved. So that's it from my side. I would be happy and willing to answer any specific question or address any queries surrounding the topic. Thank you, sir.
Thank you, Ravi. Thank you very much. Though I wanted this session of relisting should be last, but Anjali has handed over to you. So, but now I will request Mr. Bindalesh to cover the first part which Anjali has discussed, that why this delisting law is tough, what are the reason, and how it can be. I think you know, sir, because you were involved in the making of this draft and making of the delisting rules, so you are aware. So what is your understanding of this particular subject, how SEBI has made this law so tough, 10 years debarment and compulsorily you can't become the director of the company and various other aspects. Open to you, sir. Over to you, Bindalesh, sir.
Good afternoon to all, and thanks, Pawan, for giving me this opportunity to talk to the participants. You see, this is delisting is an issue which was engaging the attention of the regulators since long. I think you may be aware that what is happening, the companies were resorting to the reduction of the capital under section 100 to 104 of the Companies Act, and they are shunting out the retail investors out of the listed companies and getting delisted. In one case, what happened that the company just pass that scheme arrangement in the under the Companies Act, and send the checks of the amount to the company to the shareholders. Your shares are now over. You take your money, and our company is a private company. We are no more listed. They are become unlisted company. This kind of phenomena was happening, that where the companies were misusing the provisions of the Companies Act, because the SEBI Act rules, regulation, and SCRA was not having the provisions for the delisting of the companies. The provision for the listing of the company, but delisting was not available in that pronounced manner. So this was engaging. Other trend was seen by us, that the companies, when they were on the verge of breakout or big, they are looking for that, they will big breakout of the business will be there, they will seeking for delisting through the scheme arrangement, other thing. And then they used to talk about that, okay, we will come after listing and with a great valuation. So in that process, the investors were suffering a lot. And then all these, when the issues are emerging, then we have to step in, SEBI has to step in, and we start debating and discussing about the issue of delisting, that how it should be taken care of, what kind of safeguards should be put in, how to protect the interest of investors in these listed companies which want to go for delisting. Because the SEBI major the objective which basically drives all our action virtually, whether it's the performance or regulations or the enforcement, is the protection of the interest of investors. And other side also, there was the requirement from the company side also, that we want to get delisted also, if because especially this kind of things are coming from the MNCs. That say okay, that is a subsidiary of a international company MNC which is working in India, and now due to their other regions or their consolidation, this and that, they want to go for delisting, but the provisions were not robust for that, and the exchanges were having their own way of dealing with this kind of things. So there was a requirement from request and requirement from these kind of companies also, that they should be provided the opportunity of getting exit from the system, and delisting should be permitted, and for the rules and regulations should be framed. So taking into account all of these things, it was decided that okay, let us work out something on. But the issue was paramount, that how to protect the interest of investors. So first of all, I'll tell you that this 3 years issue for the voluntary delisting came from that okay, now you say, okay, I want to delist it. You want to pay the money to the investor, whatever you feel. You make some valuation, give it the investor money. And then after some time, you come back and say, okay, I want to get listed at a higher valuation, and I will give the share to the investors on a higher valuation. And in the meantime, make all the profit to the private hand. So this 3 years restriction was come from that if you voluntarily are getting delisted, if you want to relist, at least 3 years cooling period will be there. It should not be that today I delist, tomorrow I come back, I want to get relisted. So some cooling period should be there. And when you're going for delisting, because you came with the promise that you will remain listed, and you raise the money from the public, now you cannot make it in this manner that you just delist and then relist. This cannot happen. Some cooling period need to be there, and that was 3 years was considered to be a appropriate time for that matter. Other thing was also that it is felt that whatever the system you prepare, if the exit is not available, then entry becomes a bit difficult for the people to take a decision whether to enter into that, if there is no possibility of exit is there. And that also one of the consideration, that we should have a delisting regulation in that place. And as everybody is aware that when the regulations were made, a lot of deliberations were done. All the stakeholders were consulted in that process. Even the CII, FICCI, investment bankers, brokers, exchanges, all kind of stakeholders were involved into that process. And then the famous reverse book building was also brought in to have so that the investor can have some say in the price, which is the exit price for that matter. So these all things were going on. And somehow other things were happening along with that. One was it is a process of voluntary delisting which was going on, and so that the exit opportunity is smoothened and the investor interest is also protected in that process. Along with another thing which we find that a lot of companies were not complying. And compliance is a very, very important part, because any uninformed decision taken by the investors is a bad, it may be a bad decision. And it's not always that we should think about the investors existing or should existing in that company. We should also take care of the interest of the potential investors, which may enter into these kind of companies. So we be very, very careful in while framing the regulation in this regard that, okay, who has entered, he trapped, okay. But let us do the damage control and see that the further damage not done, new people are going to get tap into that. So what we were seeing that the exchanges were playing a truant role. I will not use this word, but they were doing what kind of activity? If somebody is not paying the listing fees, not doing the non-compliance, no worry. They're not concerned with that thing, not follow up of that kind of compliance being done or not. I'm talking this thing about 25 years back, which was happening over there. And don't pay the listing fees, suspend the trading. And this suspension going for years and years, even 10 years, 15 years, 20 years. So if a company is suspended, it's not serving any purpose of the investors. That investor cannot get the exit out of that thing. Nobody can enter also. And no information available about that company. So there became the regulatory burden on the system, these kind of companies. And there were the issue along with the vanishing companies also. The companies vanished. Now, if they remain listed, the chances of imploding those kind of companies, some security elements may come in, and they will say that, okay, these shares are variable, this and that, and they can do something like that and fleece some investor. So these kind of things were going. Then the issue of this compulsory delisting came into fore. That there should be some provision.
So please unmute mute yourself, Pawan sir. Yeah.
Yeah. Hello. Hello. Yeah.
So then from this only it came out that there should be provision for compulsory delisting also, because delinquent promoters cannot be allowed to take investor on for a ride for a longer time. They have to comply. If they don't comply, without compliance, any decision making by the investor will be not in a desirable situation, and we need to avoid that kind of thing. So if you notice that the first provision, because this is listing is done under SCRA Act, it's not done under SEBI Act. So first time the provision for the delisting by the stock exchange came in 2004. When the SCRA Act was amended, it came in 2004. Before that, there was no provision was there available in the Act per se for doing the compulsory delisting of any company. So, but there need to be put in checks and balances all on the system. It can't that happen that on the wind and fancies of the exchange, the companies get delisted and to have and promoters and company face the consequences for that. And in the process, investors also face the consequences for that. So for that, robust mechanism was made. And one thing was made very clear to the exchanges that listing fees non-payment should not lead to the compulsory delisting. I don't know now what is happening, what not, but at that time the message very clear to the exchanges that non-payment of listing fees should not be the sole cause for the suspension or for the delisting of a company, compulsory delisting of the company. So this process started by that. I tell you that when we took the step, about 1,000 companies were suspended in the BSE for a very, very long time. So somewhere some closure was to be put in over there. And when these regulations were made, the number of checks and balances were put in place. That full SOP was made for that thing, that how and what stage, different stages will be there, and how the penalties will be, and harsh penalties will go with each and every stage. First, fine, then the promoter defreezing of their demat account, this and that. So the grading of the punishment was also made out, and the compulsory delisting was is a very last stage provision for that matter. And in that also, it was not left to the discretion of the stock exchanges that they can do anything. It was very much suggested that there should be a panel who will committee or a panel that will look into this thing. With the two directors will be there from the stock exchange, and one will be public interest director. One will be from the investor association, going by SEBI, one from there also, so that they can take care of the interest of the investor. And the ED or the secretary of the exchange will be forming that panel, so that a considered decision can be taken. And every stage it was made this thing that they should be taking informed decision, and every opportunity should be given for the dealing companies to comply with the things. So again, and this thing was given to them. Okay, you comply with the things, comply with the things. But if after again and again, despite giving up enough opportunities, they're not complying, fine was not a part, but the major issue for the purpose of delisting. If the companies are making compliance, they make the compliance, then it was understood that okay, in that scenario, it will not be delisted, but something will be done for them to recover the penalty in a normal course of business. But when the companies are not complying with the things, so it will become imperative that the compulsory delisting should be done in that scenario. Then come the question that which is being debated over here. Ravi was also talking about that principle of natural justice not followed in some cases. Some cases, this even order was not served or the notice was not served. I understand that these kind of things should not happen. You see, principle natural is very paramount, and every chance of hearing should be given, and opportunity should be given to the person to present his case. And if it appears to be genuine, and that should be considered, and the decision should be taken, and this is being considered also by the panel, because if you see the constitutional panel, they are not just the regulatory person who will just go for that thing, or they will take care of the interest of the exchange only. They will take care of the interest of the investors also. So these kind of thing, if it is happening, that it is not a desirable thing, that proper hearing is not given. But what happens? The company also does not respond. They're not available on the given address. They change the address. They know filing in the MCA will be available. So in that scenario, it is very dangerous for the exchange to keep such kind of companies listed, so that because the new investor maybe get trapped into that, and we know that how the mischievous people use these kind of tactics to trap their new people. That thing. So this was going on, and another issue which I was hearing that is being raised is the debarment for 10 years. That it is a too big punishment for that. It is like a capital punishment to the company. But I understand if you make I have not analyzed the data, but you analyze the data, and if you try to segregate the nature of the companies with compulsory delisted, I believe more than 95% companies you will find which were not doing any business, which were just a paper companies, no compliances were done, no filing were being done by any with the regulator, whether MCA or the exchange, and it is very required that these kind of companies should go out of the system, because the regulatory burden for keeping a company listed and to monitor its compliances is also have a huge cost. And if you see these kinds of companies, when I will talk about the capitalization of these kind of companies, I think this will not be even the 0.01% of the total capitalization of our markets. So to put the substantial regulatory resources to deal with these kind of companies, I think is not commensurate with the desired results. So somewhere some balance has to be made, and we should see that that the proper hearing is given, proper natural justice principles followed, and then let them go out for 10 years. I don't find that that is a very, very harsh thing, because if they want to really come back, they can always, there's a clause, regulation 42 in the delisting regulation, that can be always looked into. And I think certainly, I've not seen those kind of cases, but where the real intention of the company and the promoter shown that they are really interested in reviving the company, or they want to come with the issue of some other company, that may be considered. But I'm not sure that, but that can be, if you can convince that yes, the what has happened, and now we want to do the course correction. I think maybe consider, maybe I'm not sure, but maybe that can be involved. But 10 years per se, I don't believe that is a issue which we should get bogged on that much. You make it 5 years, what difference is going to make? Make it 6 years, what difference is going to make? 10 years appears to be a very long time, but I don't think 10 years is a such a impediment or such a thing which need to be debated, discussed, and I don't find the companies which are going for compulsory delisting. If somebody is really genuine company is there and they're really interested in complying, they don't want to do the compliance, they always get the relief from the SAT, or even I don't believe that stock exchange will going to delist that kind of company. Maybe few companies may be there that where the pension is violated, or due to some reason they were not able to comply with the thing, and where if they present their case properly, I don't feel that they will go for the compulsory delisting. The stock exchange also considerate that the panel which is formed, that is also very considered for that matter. But they have to take care of the interest of the investors in that regard. So what I say, the 10 years, making 8 years, 5 years, not going to help anything. This 10 years is okay. Let it be remain there. And as we gain the experience after that, because now I think a lot of deadwood has been cut off, because we carried the legacy of the 1988 listed companies, that period prior to 1988 and out to 88. Then we have the legacy of the company listed in 94, 95, where the lot of companies become vanishing. Now I think that deadwood is now cut off, and the incidence of now delisting should come down. Compulsory delisting should come down substantially. But if now these cases are coming for compulsory delisting, then something wrong with those companies. And the exchanges and the regulator should also be more considerate where the genuine cases are there, and due to some difficulty, some problems, they're not able to comply with that. Some hand holding need to be done to those kind of companies. Management need to be sensitized about the importance of the compliance, and how to protect the interest of the investors in those kind of companies. I think that is a more positive approach need to be taken in that, instead of being so harsh on the company while taking the decision for compulsory delisting. Enough opportunity should be given. Try to understand the problem of those companies, and if required, the panel can be SEBI may consider reconstituting the panel, bringing the more the one industry country may also can come in that kind of a panel, who can understand the nuisances of or the issues of the industry when this kind of things happen. Something can be done. But I think the regulatory side, no tinkering per se is required. I was just going through the regulations after a long time. One interesting thing I found in that, when this issue of the valuation was coming, that how to value the this thing in the compulsory delisting, because when this latest amendments has been done, I think something has missed somewhere. And what they say in the valuation, what they say, valuer to determine the value having regard to the factors mentioned subsection 2 of these regulation, and for the regulation 20, subsection 2 of regulation 22 is to be considered, factor to be considered for that, and regulation 20 subsection 2 has been omitted. in September 2024. Therefore, just look at that. In the regulations, when the valuation is there it is mentioned the value will take the factors mentioned is regulation 22, 20 with the subregulation 2, but that is omitted in September 24. So that may be, I think you can suggest to the SEBI to get it corrected somewhere.
Yes.
So what I'm saying is this delisting issue is an issue where we have to do the balancing of the interest of the investor and the corporate side also. And non-compliance is a thing which is very, very difficult for the regulator to digest that thing. Okay, you go on non-complying and then we will allow the listing. And always the judiciary is always there, appellate tribunal is there to look into the cases where something excess has happened and they may try to do the course correction. And they will lay down the new principles and new guidance which comes to the regulator for that matter. And this is taken into account by the regulator by taking the further decision. And I think so with these words, I will say that this delisting, compulsory delisting is a virtually, we should mature our market to such level that we do not have to resort to this compulsory delisting. And the investor interest is protected, companies grow, they comply, and let our capital market flourish for that matter. Thank you.
Thank you very much, Bindlesh sir. You have really given the depth and the information of this and the purpose, because so many times the companies normally they argue that I want to delist, what is the problem, but they are not understanding the basic concept. So there was some discussion going on this delisting issue. So I told that it is your company. He was arguing that it is my company. Majority shareholder is my. Only 10% is public. So I told him that because of this 10-25% shareholder, you are listed. Suppose these shareholders are not there, you are not listed.
Yeah.
So there is no free lunch. Because sometimes what is happening in the private limited companies are also arguing that it is my company, why register a company or ministry of asking all these information. So I was telling everyone that if you are a company means there is a benefit, that continuity, perpetual succession, liability is on the company, not on you. Now, what is the cost of this? The cost of this transparency. The cost of this to give information to the stock exchange. Oh, sorry, the registrar of companies. So people can see if you are taking loan, then you have to create a charge. All these things are there. So sometimes people confuse that they are making company and because they made a company, so it is everything is theirs and they don't want to do this. Same thing happened with the delisting. Because very few shareholders are there. I am the majority shareholder, so my entire thing is mine. So this is not your listing cost is the reason that you are here. So this is always
one line I will add, that people feel the equity is the least costly funding, but I say it is the most costly funding.
Yeah.
Which you need to change your mindset completely when you take the equity funding.
Yes.
It is not your company, it is our company. It is a public company.
Yeah.
That has to be understood very clearly. Mindset need to be changed of the promoter for that matter.
Bindlesh sir, whenever somebody is coming for unlisted company and the promoter comes and they ask it that I want to come out with the IPO, I'm asking them, are you ready? That one shareholder of 100 shares will come to your reception and will say, I am the owner of this company. I am the also owner. Will you tolerate this? So if you tolerate, then you should go for the public issue. Otherwise, you don't go. Okay. So thank you very much. So Anjali has given the delisting process, why, how, and then how the relisting is possible. Ravi has made out in the case law. Now we have, I think, more than 15 questions, and then I have around 10-15 questions with me. So we have to just do this justice to everyone to understand. So Anjali, I'm starting. Ravi or Anjali, anybody can give, and wherever Bindlesh sir can add, they can. Can a director in delisted company become director in any other private public company? What is the rule? Please clarify. I think he's asking unlisted. So
Unlisted.
give answer
There-
private, public,
Yeah.
and listed.
So
There's
for
no-
a private public, sir, you were saying something, sorry.
Yes.
Yeah, there's no issue. There's no issue to that.
Yeah, for these companies, no issues. Unless for a listed company, you cannot become a director.
Firstly, I tell you that even that private or public company not listed, they should also understand the why this person has got his company delisted, what company delisting taken from his company, because these impact the overall
Under
conduct
AG?
of the board also. So they should be very careful while inducting such kind of people. They can no legal bar, but the company should be very careful while inducting these kind of people.
Agreed, sir. Yeah.
Sure. Okay. Is IBC case delisting is voluntary or compulsory, Anjali?
So that's a special case that is by operation of law.
Operation law.
It is neither considered voluntary nor compulsory.
Okay. If a company is listed on BSE but voluntary delisted on NSE, and how now the company wants to relist on the NSE, then how can it be done?
It will have to follow direct listing norms, but we have to see for a company which has already been delisted by NSE, direct listing may not be permitted. We'll have to see that.
Okay. What is the time limit for revocation of delisting?
Revocation of
Delisting.
no. Delisting of revocation.
I think
The question is
He
you
wants
listed the
revocation of
BSc,
suspension.
it is listed on BSc, but is delisted from the NSC. Now he want to get relisted on NSC. This is the question, I believe.
Yeah.
This is a question. Then the 3-year cooling period will be there for the listing or relisting on the NSC.
But another question person is asking timeline for revocation of delisting. So there is no revocation of delisting. Delisting.
No revocation.
Revocation of
it is very
suspension.
clearly mentioned the regulation. It will be as it is a new listing.
Okay. Rohit Johari, you have asked very big questions that I will cover last. If a next question, if a 6-month period for delisting will be applicable on privately placed debenture listed company?
No.
6 months, no.
It is for the equity only. This is for
Equity.
equity only.
Okay. If you are delisted in one exchange, automatically delisted in the all other exchange in India?
Yeah. Compulsory delisting, yes.
No. In the case of compulsory delisting, yes.
Yeah.
Otherwise, not.
Yeah. In case of compulsory delisting, whether opportunity of being heard to the company will be provided?
Yes, it is provided. And that's what I said in my presentation as well. Ki SEBI exchanges take almost 2 years before they take the step of compulsory delisting. They provide various opportunities.
Can a company which has been delisted 20 years ago and continue to be listed on regional stock exchange and currently listed on MSCEI in a compliant status be listed again on BSE through direct listing route if it is meet the direct listing eligibility criteria?
Yeah,
Yes,
it can.
no problem.
It can, sir. It can.
It's a listed company. Simple listed
Yeah.
company.
It is a MSCI listed company.
Additional exchange, they look seeing the listing. Simple.
Yeah.
Okay. Is voluntary delisting and relisting, what is the cooling period?
3 years.
Voluntary delisting is there, then how many times?
3 years. 3 years.
3 years, sir.
Okay. Now, I will take the Mr. Jory's question, then I'll come to my question, which I have received through mail. There is a big question, thank you for knowledge entitlement. We are a company which got listed on Delhi Stock Exchange and Allahabad Stock Exchange, no stock exchange, bhai. Kanpur Stock Exchange. In the year 98, in the year 2016, due to closure of Delhi Stock Exchange, or Kanpur Stock Exchange hoga ye, were closed and provided the option to list their securities at other stock exchange. In 2016, our company got listed in MSCI. In year 2021, the secretarial auditor in the secretarial audit report provided the observation that the company is not complying with the regulation 38 of LODR. minimum public shareholding. After that, MSCI suspend the scrip in December 23. So it is a listed company.
Yeah.
Okay. And 23, the stock exchange MSCI is suspended. In December 23, MSCI published initial public announcement under Regulation 32 of SEBI delisting, and then no representation has been sent by the company in 15 days from the newspaper publication for not delist the company. Now, the violation of MPS come into effect in 2021 after verifying the secretarial auditor that the shareholder shown in the public category in body corporate is 30% of the promoter shareholding, and the promoter already holds 60% of the shares in the company, which accounts to 90% of the share capital held by the promoter of the company. The net worth of the company is 130 crore as per the last audited financial year statement. The company has never been traded in the stock market since listing. The suspension on security is stand till date, but the exchange is not compulsory delisted the company. My question is, what are the criteria for calculate the fair market value for exit opportunity in compulsory delisting? Can a pen be defreezed if the promoter exercise the exit opportunity for the public shareholder of the company? Duration of exit opportunity for public shareholder, the promoter need to be exercised. Can fair market value calculated by the exchange to be challenged in SET? And I joined the company in July 2024 as a company secretary. Should I also be debarred from security market for the period of 10 years as a suspension took place way back in 2023. So his last question, sir, you can give answer. That company is not delisted. He was not there earlier. Now he has come and now company will delisted. So he will be debarred for 10 years.
Till the time the company is suspended, there is no debarment on him. But if the company is compulsorily delisted by MSCI, yes, the debarment will follow on him as well.
This person will also.
Yes, a person's responsible for doing the compliances.
So
the professionals are getting caught.
Yes, Pawan, simple answer to that. Why they don't comply? Why they're looking for community listing? Yeah, when
so
you
Mr.
have
Jory,
time,
you comply and yeah.
Why don't you comply? Simple.
Right.
Open the okay. What are the criteria to calculate fair market value for exit opportunity in a compulsory delisting, Anjali?
The registered value will look at the provisions as given in takeover regulation, which Bindlish sir was also trying to say, regulation 20 sub-regulation 2, which has been omitted. But otherwise, the provisions talk about takeover regulations. They borrow the provisions, valuation provisions from takeover regulations. And if he's talking about the net worth of the company is 130 crores, that means there are good assets in the company. They are good. There's a profitable company. So valuation will be determined accordingly.
Hold on. Okay. Anjali, can a pen defreeze if the promoter exercise the exit opportunity for the public shareholder of the company?
Yeah, that can happen.
Okay. Duration of exit opportunity for public shareholders, the promoter need to be exercised?
So there are SEBI circulars to that effect. Delisting regulations do not talk about anything, but there are SEBI circulars which talk about exit. There are provisions for different types of categories.
Okay. And what about can a fair market value calculated by exchange be challenged in the SET?
Ravi?
Yes, it can be.
Anything.
Yes, it is not free from judicial scrutiny.
Okay. What are the routes for relisting after cooling period on NSE?
Routes for relisting.
That is a new listing simply. A new
Yeah,
listing,
it's
they
an
comply with
IPO.
everything.
You have to come out with an IPO.
Okay. Okay. Now, another question, why is the company allowed to operate until 100% of public shareholders amount is paid to the shareholder?
I didn't get this question, sir.
The question is that why we are saying 100% payment should be made to the shareholder, public shareholder.
But it is a listed entity. as you said, belongs to all the shareholders. So they have to be paid back. If you're getting delisted, if you're being removed from the system.
Okay. Okay.
Investor
If the
protection
full
measure.
payment 100% for public shareholder is not.
Sir, I think Bindish sir was saying something.
Yeah, yes, sir.
It is the investor protection measure that because
Yeah.
the investors are there and now they need to be given the money back because you are came with the promise that it remain listed, it will be free transferable and the compliance will be there and the fair price discovery will take place where you can trade in this stock. Now you are reneging on these promises and getting delisted. So pay the shareholders. Na? Shareholder paid you, na? Paid the company when it was it got listed. Now you pay back to them.
Okay.
And who is responsible? The promoters, who are the people who are responsible for the compliance, etc. They have to.
Okay. Mr. Malla, we will share this copy of presentation. Vijay sir, this is a very interesting question. Before granting permission for delisting, the company law board, the CA Institute should conduct a thorough investigation into the operation of company to determine whether there has been any deliberate attempt by the company to defraud or mislead the public.
You to understand one thing very clearly that the delisting process has nothing to do with the fraud, misappropriation, other things. This is by the a normal process because what is required that the investor should get the proper information while the trading is taking place in any company, securities of any company, they should have proper information. Once that information is not coming freely and at a timely manner for the investor, there is a case for that these companies are not fit to remain listed. Whether they have done the fraud or the accounting fraud, money siphoning, this and that is totally separate issues from that. And if there's some whisper of that thing and it comes to the notice of the regulator, then generally these are referred to the relevant authorities to examine those aspects.
Okay.
Sir, yeah, I agree with what Bindish sir said because then forensic audits come into picture, which can happen even after the compulsory delisting.
Okay. Is it observed that once the company raised fund from the public, it often plans to systematic strategy to delist and misuse public money for personal gain? Is it correct? Any example of this type of cases?
A very generalized statement is being made. This is not, you see, one thing we should have a positive thinking, let me tell you. We are here not to stifle the things and to start with the notion that people are cheats and this and that. I always maintain this philosophy, trust and verify. I never believe in the distrust and crucify. So we should trust the people. Why anybody will come to the market with the fraudulent intent? Okay, it may be 1 or 2% may come, but we cannot make our rules, regulations, and systems to take care of those guys. Then we bog down with the things. We have to see the positive side of the thing that we want to develop the capital market. We want that the corporate should be able to raise the money in a very, very smooth manner without least hiccups and a proper manner. They should be able to raise the capital. That is the purpose of capital market. Efficient allocation of the resources is the capital, is the purpose of the capital market. We cannot have this kind of notion in, but the problem comes then only when we start having that kind of mindset while framing the regulation, then we start the things start falling apart. We should have a positive attitude. That's my view.
Each director should be held personally responsible for any loss of the public capital if legal violation or misconduct are observed. The director should be prosecuted, imprisoned, and their personal asset must be seized to compensate for the public loss.
Case to case. This cannot be generalized. Naturally, something is going wrong. The wrongdoer should be held responsible for that.
Okay.
And SEBI has tried to do the same by way of freezing off the demat accounts of the promoter.
Whatever possible.
You have come across any type of cases like this?
आप सर को पूछ रहे हैं सर?
Ravi.
Where directors are made personally liable to restitute.
No. The people are misused for the delisting route, something they have done.
Certainly, I would not, I would say it only on no name basis, but this is a strategy to take the value negative and then get it delisted.
Yes. But Ravi, that will be very, very minuscule. But when I will talk
Very
now,
minuscule, correct.
I see that my capitalization is more than 4 lakh crores.
Yes.
So I cannot get bogged down by this 500 crore company, 100 crore company, 50 crore company. I
Correct.
cannot be bogged down with that. If I start working on that, then I think we are missing the wood for the trees.
Correct, sir, correct. But let me tell Pawan sir this thing. Delisting could lead to generational trauma
Yes.
in the listed space.
Yes.
If
Agreed.
Yeah,
somebody,
IBC we use for
Yes.
that purpose, for getting all the statute dues
if
away.
my ancestors got delisted, maybe it will tempt me also today to go and get listed, because I'll have to always disclose that my father, my grandfather,
Yeah.
he had a company, got delisted. So it is a taint, indelible blot in that sense.
Okay. Ravi, one question. After 10 years debarment period, what condition must be fulfilled for company to re-enter in the capital market?
They have to come, as said by Vindlish sir and Anjali ma'am, with IPO.
Okay.
Plus
They should
an
make all
exit
the-
also. Exit
all the-
also needed to be given.
Yes,
That is
and if
fresh
exit
listing.
is not given, its 10-year debarment might get over, but all the parallel collateral action, they continue.
Okay.
They remain frozen. They can't come be associated with securities market unless until they give
And
exit.
Vidya sir, they have to write in the prospectus also that this company
Yeah.
was then, huh?
Disclosure has to be made.
Yes.
Whatever it may be. If somebody murdered also, that is written in the prospectus
Yeah.
that I am murdered and but still not convicted. Whatever it may be, it has to be done. Disclosure has to be made. There is no.
Okay. Is reverse merger is a viable route for delisting a previously delisted company? What are the risks involved? Anjali, is it possible?
So, I don't think exchange will allow, or SEBI, because now we need exchanges and SEBI's NOC. And the moment we say that the company has been compulsorily delisted, they will not allow the NOC. They will not grant the NOC.
Okay.
Mentioned very clearly, directly or indirectly.
Yeah.
Yeah. Okay. क्या a reverse merger is viable of route for relisting a
पर ये तो
private?
ये तो आगे वाली, it was he
ये
just
हो
talked
गया.
this
sorry.
question.
Okay. Can a group company or SP be promoted by the same promoter seek listing? What precaution must be taken to avoid regulatory conflict?
It can't get listed.
For a period
But the
of 10
promoter-
years, no.
Okay. Whatever precaution you can do, you can't do. Can a compulsory delisted company subscribe to equity share in a preference share by another listed company?
Why not?
Now,
No restriction.
no, yeah, because
No restriction.
exchanges, nahi sir, आजकल exchanges are not allowing.
Yeah.
In their checklist, they ask for it whether the allottee is a person who has been compulsorily delisted.
No, there are two
It has
things.
been-
Once you are coming as a allottee pre-IPO in the potential allotment, something like that. That is the one part. In the public schedule, you are taking it. Who can stop you? If you are applying on the IPO, who can stop you?
IPO nahi sir, preferential. I think the question
Yeah, that will be.
pertains
That
to
certainly will be.
preferential.
You see the fit and proper to see, na, for that.
Yeah.
If the preferential allottee, they have to fit and proper.
Yeah.
But you have to see that.
So you can apply in IPO. There's no restriction, but
Yeah.
preferential you can't.
सेकंड वाले में ले लीजिए ना. सेकंड
Yeah.
वाले ले लीजिए आप, कोई प्रॉब्लम नहीं है. बट अगर आप एज ए इन्वेस्टर आ रहे हो उस कंपनी के अंदर जो है स्पेसिफिकली, देन द मोर ड्यू डिलिजेंस रिक्वायर्ड फ्रॉम द कंपनी साइड आल्सो ना. Not from regulator side or exchange side, in the company side also more diligence is required.
Okay, Anjali, can a company come out with the right issue if any of the promoter director has been promoter director of the compulsory delisted company?
Rights issue, no, they will not. They'll again be, the company
No,
will be
they're unlisted, they can bring the right issue, but that shares will not be credited in the account of the promoters who have been debarred. Their accounts remain frozen if they have not given the exit option.
And that share will be called unlisted shares because
Naturally.
Yeah.
Okay. Okay. Anjali, what are the operational and reputational steps to company should undertake immediately after compulsory delisting?
So I would rather say before compulsory delisting, the company should take the steps. एक बार उस स्टेज पे पहुंच गए फिर तो कुछ वो सिचुएशन अराइज नहीं हुई, अदरवाइज वो सैट अपील ही बचेगा. बट बिफोर कंपल्सरी डीलिस्टिंग, एक्सचेंज विल गिव यू एम्पल अपॉर्चुनिटीज टू present yourself. It's better to take the steps right then and there.
Okay, Ravi, can you share some live case study where company successfully navigated a compulsory delisting situation, either by challenging it to the or complying with SEBI directive?
I can share 10, but let me share the most recent one.
Which you have done, you just share that.
Yes, there's a company called Samtel. They were compulsorily delisted after being given opportunity of 6 months to comply. But as I told that the exchanges had sent notices to some wrong address, there was no effective service to them. So they filed an appeal, and then they got a chance to submit their compliances and all. I think it is all sorted out by Anjali ma'am and her team. And now they are on path of getting relisted. So there could be umpteen number of situations, adding to what Bindlish sir said. There, delisting strikes balance between two competing interests. Maintaining the listed ecosystem healthy, not allowing rogue companies that can be misused in the economic stream to continue exist in the listing ecosystem, and at the same time ensuring that the companies are not striked out or delisted as per whims and fancies uh, uh, of one's perspective only. So I think it carves out the balance well. And in fit cases where the intention is there, conduct is bona fide, and they can show sufficient cause, uh, one may approach securities appellate tribunal. And as I told, they do not approach the matters with a hyper technical approach, and cases have got relief also.
I personally feel that if the case is present properly with the panel also in the exchanges, then
Yes,
that can be taken. But problem is this, that they don't present the case.
they don't.
Yeah.
People don't even respond to the notices. And
Yes.
after the everything done, then they have everything and to go to the site.
Right.
Before that,
Right.
they will come present the case. If they present the case, I don't believe the panel which has been constituted is a quite reasonable panel,
Yes.
taking care of interest of the different. I was just suggesting that you can suggest, Pawan, that an industry representative can also brought in this panel, so that industry perspective can be brought in. That can be suggested to SEBI. That
Yes, because so far as only
industry
government
representative is not there.
nominee, investor, all these are there,
Investor
but there
representative
is
is
no
there,
industry representation.
PID is there, director is there, secretary or ED of the exchange is there. If one industry representative is also brought in, because we learn from the experience.
Correct, correct.
So I think we can suggest that thing.
Yes.
Right.
Okay. So Ravi, any other experience of this case which has come? What types of questions SET has asked? What types of question the other advocate of the stock exchange has opposed?
They say, you see, the standard response of stock exchanges once an appeal is filed is that order has been passed, it has been duly passed after being provided. I mean, the notices were being provided reasonable opportunity. They did not submit this. No merit in the case. It's beyond our power to now revisit the order. We can't recall our order, and all those grounds are taken. What bench usually asks for is what is the reason why you have not complied? For how long you have not complied? When was the delisting order passed? Were you given any opportunity before the delisting order was passed? And how, I mean, with what alacrity you are coming to the tribunal? Are you indolent or you are diligent? These are the aspects in which the tribunal really goes and sees beyond, uncovers the layer and sees beyond it. So while deciding a delisting case, it's not only about the company, because company invariably in all such cases is a company which is not functioning or is an inefficient company in terms of its compliances, and even and in many cases in terms of its business operations as well. What they really look, whether the people behind the company are steadfast, they have the intent to comply, are they forthcoming, are they making a concrete, are they willing to submit a concrete plan to the court, uh, they ensure that someone is not trying to pollute the pure stream of justice by taking them for a ride by overreaching or bypassing the provisions and overreaching the tribunal with requests which garble the facts. So this is the basic inquiry which is made by a bench, and that's commonsensical also. I'll tell you in one case, all that was argued before SAT was that consequence of delisting would be this to the promoters. It was relating to one company, BPL. Binli sir would remember. It's an old case. So there, all the arguments made by appellants were that promoter will now face this, they will have this difficulty, that difficulty. SAT noted in their order. They said, while we have heard the appellants at length, none of the argument is about the public shareholder, the money invested by them, what will happen to them. And then they said with that this is a case where with impunity they have tried to overreach, and we find no reason, and they did not give any relief. So one needs to be really considerate, and one need not to be just be seen. One must not only show themselves as fair, but also be fair when they approach a tribunal for lifting of delisting order, or to ask a chance to fairly comply with the provisions of law. So I think these are all, sir, and it all depends on also case to case. What is the complication in the case? Sometimes most of the cases, and that's unfortunate. Most of the cases they are lost by exchanges because they don't follow their own procedure. The SOP that Vindlish sir said, there is a strong, robust SOP, but you would find, and that's very unfortunate, the committee is not constituted. Some random officer is passing the order, not disclosing the name. Councils are asking in committee, please disclose what is the composition of committee. Not given. Never told. I do not know. I mean, if these things are to be fixed, we can bring down the litigation. And why only litigation? Half of the frustration also. Because people will feel that justice has been served to them. Because of these wrongs, the litigation are protracted, and then outcomes become messy.
Some handholding can be done for before the passing this kind of orders, compulsory delisting. Some handholding can be done, and a compassionate hearing can be given to understand their concern. But the rogue are rogues, and that need to be punished. But we can very well understand. I tell you that when you meet the people in a committee or something like that, you can understand who are the rogues and who are the genuine people. You can understand that thing.
Yeah, that is absolutely right. Absolutely right. Okay, so friends, it's a time to close because we have all the questions which we have answered. The Anjali has given a presentation, Ravi has given the case law, and Bindilesh sir added the depth of the subject and the issues connected to this. And so I thank everybody, Anjali, Bindilesh sir, Ravi. As a ritual, we just want 30 seconds from all the participants. I will start with Ravi about this topic and what message you want to give.
I think diligent delisting has a cure. It's not incurable. One needs to be diligent and not indolent. And the same goes for stock exchanges also, who administer these orders.
Okay, Anjali.
A debarment period has been brought as a deterrent so that all the companies which are listed on the exchange, they should understand that the money they have taken from the public is the property of the public, and it's not that they can go away with that money. And if we do timely compliances, if we are actually intelligent and diligent about the compliances, this situation will not arise.
Okay, Bindilesh sir.
I will say simple one thing, that let us have such a robust and matured capital market that we need not to resort to this compulsory delisting.
That's absolutely right, Afsar. So friends, so today we have covered the delisting. Delisting is just like you either, because everything, if something is born, it has to die also. But delisting is a situation which is you are not in a dying position and you are not in a living position. You are, sometime Anjali was mentioning about coma. So coma person is not aware that what is happening. But here you will face all problems. So you are like a dead person sleeping, who can understand everything, who can see everything, who can eat, but he can't move certain things. So delisting is just like that particular ills, and it is not good for the capital market, because those who are investing money, they should not be suffer their hard-earned money, whether it's a small amount or big amount, but it affects the entire market's credibility. So the SEBI's law is tough, and it should be. And the punishment which is there, the best way to remove this, that you comply and you make your company active and do it. So thank you very much. Thank you, Mindresh sir. Thank you,
Thank you.
Ravi.
Thank you. Thank you, sir.
Thank you.
So
Thank you,
thank
Indresh
all
sir.
participants. Friends, this knowledge share journey will continue, and our next topic is on AIF, that we will send it to you. And for the participant, we are sending presentation to everyone.